You've heard the term tossed around, ex parte order. But what does it actually mean? And how is it that someone can walk into court alone and walk out with a legal order that affects your whole life? Let's break it down. The term ex parte is Latin. It means from one party. In simple terms, it's when a judge hears from one side only, without notifying or hearing from the other side. Now, before you panic, understand this. It's supposed to be used for emergencies only. Think situations involving danger, threats of harm, or immediate risk to children. But just because it's supposed to be temporary doesn't mean it always feels that way. This isn't new. Ex parte powers date back to English common law, when courts of equity had the power to stop harm before it happened. That idea carried into American law and eventually became part of New York's family court process. Here's how it works in New York. One party files a petition, usually for custody, an order of protection, or to stop contact between the other parent and a child. They request emergency relief, meaning the judge looks at their paperwork without informing the other side. The person must also include a sworn statement explaining why giving notice would be dangerous or cause unfair harm. If the judge agrees, they'll issue a temporary order, like a protection order or emergency custody. And just like that, someone's life changes. But this order doesn't last forever. At least it's not supposed to. A hearing is scheduled, usually within a few days. That's when both sides get to speak. The forms used in this process are specific. The petitioner files something called a GF-5B affirmation, a legal form explaining why emergency relief is needed. The judge may sign a temporary order of protection, also known as a GF-5, valid until the full hearing. Everything gets filed at the ex parte office in the courthouse. In New York City, that's usually room 315 at 60 Center Street. Sounds fair, right? Except here's where things get murky. The judge only hears one side of the story. That temporary order, it can remove a parent from their home, take away custody, or restrict contact with their kids, with no chance to defend themselves up front. And if the courts are backed up, that temporary order might last weeks or months before you get to tell your side. That's not due process, that's damage. If you're served with an ex parte order, don't panic, but take it seriously. Read it carefully, follow it, even if you disagree. File a response immediately. You can request a hearing to modify or vacate the order. If it's extreme or unfair, you can even appeal the decision under CPLR 5704 subsection A and have it reviewed by a higher